Presenting the appeal, Bank of Cyprus UK Limited and Menelaou.
Mr. and Mrs. Menelaou lived with their children in a house which was mortgaged to the Bank of Cyprus to secure Mr. and Mrs. Menelaou's borrowings of around £2.2 million. They decided to move and got the bank to agree that it would release its mortgage so they could sell their house, repay the bank £750,000 and use the rest of the proceeds, £875,000, to buy a new house at Great Oak Court, which would be charged to the bank for the balance of their debt, £1.45 million. Mr. and Mrs. Menelaou entered into a contract to sell their old house and a contract to buy Great Oak Court. When they entered into the contract to buy Great Oak Court, it's common ground that the vendor of Great Oak Court obtained a lien over it for the purchase price of £875,000, a lien which was to be redeemed when that sum was paid on completion of the sale. With the bank's agreement, the Menelaous decided that Great Oak Court would be transferred to the name of their daughter, Melissa, and that duly happened when the purchase of Great Oak Court was completed. The document of charge mortgaging Great Oak Court to the bank was executed and registered without Melissa's knowledge. When she discovered the existence of this charge, she realised that it had been defectively executed and was void because she had not signed it. Melissa therefore claimed that she owned Great Oak Court free of any mortgage to the bank. The bank eventually accepted that the charge was void, but argued that it was entitled to be subrogated to the unpaid vendor's lien. In other words, that it was entitled to be treated as if it had stepped into the shoes of the vendor of Great Oak Court when the sale of Great Oak Court to Melissa was completed, and therefore the bank was to be treated as having a lien or a charge for £875 over that property. The judge rejected that argument, but the Court of Appeal reversed him and accepted the bank's argument. Today, the Supreme Court upholds the decision of the Court of Appeal for reasons given in judgments by Lord Clark and by me, with both of whom Lord Kerr and Lord Wilson agree. The case was argued on the basis that Melissa had been unjustly enriched at the bank's expense, and in these circumstances, the appropriate remedy for the unjust enrichment was to accede to the bank's subrogation claim. Lord Clark and I each consider that on the facts summarised above, Melissa had been unjustly, albeit innocently, enriched by obtaining Great Oak Court free of any charge, and that this was an enrichment at the bank's expense, and that there were no special defences open to Melissa against the bank's claim based on unjust enrichment. We also take the view that, as the bank contends, the remedy of subrogation is available to the bank in this case, particularly in light of the reasoning of two decisions of the House of Lords, Rackper and Manson Investments, and Banque Financière and Park Battersea. Lord Carnworth is also of the view that the Court of Appeal's decision should be upheld, but he considers that the bank's subrogation claim can and should be justified not on the basis of a claim in unjust enrichment, but on the basis that the £875,000 used to purchase Great Oak Court had been beneficially held for the bank until it was used for that purpose, and therefore the bank's subrogation claim has an orthodox basis and can simply be traced into the purchase of Great Oak Court. In my judgment, I explain that I see considerable force in that analysis, but as it was not argued, I prefer to express no concluded view on the point. The appeal is accordingly dismissed.